Justice Sotomayor? Justice Kagan?
Mr. Fletcher, when I read your brief, I had the sense that you and General Olson, Colorado, parted ways on some matters. And I'll just, on my hypothetical, God blesses this union, I thought that you might find that more difficult than General Olson. And I'm wondering if I'm right about that, and if I am right, why, and what that says about your argument generally.
So let me give you the answer I give today. I'd start with just the same observation that General Olson gave you, which is that I think their free exercise clause issues might come into play. I'll put those to the side because this is a speech case, right? And I think what that pushes on is, can the person who's providing services credibly say, I'm not denying service just because of status, I'm denying service because there's some message that's not just tied to status that I'm not willing to speak for anybody. And to me,
gay marriages are wonderful, to take the religion out of it.
Right, so obviously Ms. Smith can say, I will not make any wedding website for anyone that says gay marriages are wonderful. She can refuse on that ground. Colorado agrees, we agree, right?
Right, I guess the God bless this union was supposed to be so that it would be, she would be like perfectly fine with saying it for some couples and not fine with saying it for other couples.
Correct, yes, and I guess it's a harder case. You know, I think it's one of the reasons why this case is frustrating is because we don't have any concrete facts. I think my inclination on that case is that I think she has a strong argument to say, really that is making me send a different message because of the context. It's not a literal test. It's not just are the words exactly the same, right? We acknowledge that context matters. And so in a case like that, I think she has a much stronger claim to say, if Colorado applied its law to make me say that, and I think it's far from clear that Colorado would, then it wouldn't be imposing the sort of incidental burden the court saw in Fair, then it's imposing the sort of direct burden you saw in Hurley, and the analysis looks very different.
Yeah, so what you said is part of what frustrates me about this case, because, you know, I guess my view when I'm trying to think up hypotheticals for myself is a little bit, it depends. On the first set of hypotheticals I gave, I would come out one way. And on the second set of hypotheticals I gave, I hope I'm not giving too much away, I think it's much tougher, and I might come out the other way. And it really depends on the facts and on what exactly Ms. Smith is being asked or compelled to do. And that matters. And we have a case without any of that in it. And what should I do with that?
So I think you should take the case as it comes to you. And as it comes to you, it's Ms. Smith saying, I want to post a sign saying I will not provide any websites for any same-sex marriages. That's PEDAP 7A.
Categorical rule.
Categorical rule based on status. And at page 303 to 304 of the joint appendix, which General Olson referred to, that's the relief that she's seeking, how she's framed her claim. What she wants is an injunction that says you can't.
Justice Gorsuch says we don't want to do things based on relief because courts are in control of relief. So take out that part of your, I mean, whether he might be right, he might not be right, but would it matter if we took that out?
I don't think it would, because what I heard Ms. Wagner say this morning when she was asked about what her client wants to do is that the services she'd provide are not limited to the ones that are described in the stipulations. She would provide something that wasn't so customized as long as it was to an opposite-sex couple, but she wouldn't provide it to a same-sex couple. That is what she is asking the courts to validate. And I think the court can take that claim as she presents it and say, on that level of generality, she is not entitled to pre-enforcement relief. But I think it can also do, because I recognize there are harder questions out there, it could and should do what it did in Holder versus Humanitarian Law Project and Doe versus Reed and say, in rejecting this facial challenge, in part, or I'm sorry, pre-enforcement challenge, in part because we need more facts and we don't have them, we are not foreclosing the possibility that there's narrow relief in future cases with concrete facts.
Last question. You said to Justice Jackson that you didn't want to belabor the point, but her hypothetical is exactly the kind of hypothetical that you're concerned about. You must have done many moots of this case and thought of many hypotheticals. What are your two ones that you're like killers? If we rule for Ms. Wagner and her client, what happens? Give me two hypotheticals.
That's a lot of pressure on my mooters. My favorite one is this court's decision in Runyon versus McCrary, which was about a school that wanted to exclude children of particular races. And it said the reason we want to do this is because segregation is important to our beliefs, and that's what we want to teach. And this court said you are free to teach segregation in your school, but you can't act on that belief by excluding children of particular races. And I think there's a private school, obviously. And I think if petitioners are right, that case comes out differently as long as the school can come in and say, when we teach, we are expressing messages, and those messages change when we express them to students of different races. I think that's very troubling. And I guess I take Justice Alito's point that I do not mean to equate those who have different views about marriage to racists, but the reason why I rely on those hypotheticals is because this court's First Amendment jurisprudence does not distinguish between views we find odious and those we respect. The same principles apply in both cases, and if the principles lead to unacceptable places when we consider them in light of odious views, then I think we have to reject those principles even in a case where we sympathize with and respect the views.
Thank you. Ms. Wagner, unless you're not through with that, sorry.
I'm through.
Okay.
Thank you.
Can I give you a hypothetical? It's not really a hypothetical because I happen to have 2 clerks in my chambers this year who are engaged. So in looking at this case and preparing this case, I looked at their websites. And so the hypothetical is about, like, I'm going to call it the standard website. They both have their names on it, the date of the wedding, a picture of the couple. Then there are a bunch of places that you can click to. And one is the schedule of events, and the other is travel and hotel arrangements, and another is favorite things to do in town while you're here, and another is registry. So that's what most websites look like, yeah? And they're not particularly ideological, and they're not particularly religious, they're not particularly anything, all right? And then there's a tagline, just like the tagline in this case, about sort of who created the website or whose graphics and design and typefaces and so forth were used in the website. And so one of them says, I'm going to substitute a woman's name just to not advertise, but one of them says, made with love by Amber, right? Mm-hmm. It's actually bigger than the 303 tagline. So I guess what I want to know is, suppose Amber wakes up tomorrow morning and says, you know what, I don't want to do those websites anymore for same-sex couples. Could she do that?
In terms of creating new websites?
No, you know, like she's providing these templates, and she has all these designs and typefaces, and that's what people use when they create their own website, because they give her the date and they give her the list of hotels and so forth. So can Amber wake up and just say, no more gay couples?
She can't say no more gay couples, but a speaker does have the ability to decide not to speak under the law. But I think the hypothetical that you're mentioning is assuming that it's a plug-and-play website, essentially, that the website is already made and that the speech creator isn't making any additions to it.
No. I mean, just like, I have to think that your client does something similar. You have lots of graphics, you have, typefaces, and, maybe, some are a little bit more you talk to the client, and some are a little bit less you talk to the client. But basically, clients are coming in and they're saying, we just want a standard website, that tells people where to stay and how to travel there, and what our favorite things to do are. And the question is, can a website designer say, sorry, that's not my kind of marriage?
The website designer...
There's no scripture, there's no ideology, there's no nothing.
There is ideology, and this court has already recognized that there is ideology and different views on marriage, and the court's promise in Obergefell is to protect those who would believe marriage is between a man and a woman from having to express a view that violates their conscience. But
so I think that if I understand you, you're saying, yes, she can refuse, because there's ideology just in the fact that it's Mike and Harry and there's a picture of these 2 guys together.
That is speech. You are announcing a wedding, and if you believe the wedding to be false, then the government would be compelling you to say something that you otherwise wouldn't say, which makes it content-based.
So it's really nothing about the content of this speech. I mean, it could be Mike and Pat, and you don't actually even know whether Pat is a woman or a man. There's really nothing about the content of this speech. Am I right? In your case, you have like scripture examples, and so that might, be different, maybe. But you're being forthright and saying it's really not about that. It's nothing about the content of the speech. It's just that the content is being whatever the graphics and typefaces and, which hotels are, have been reserved for the wedding, it's being used in a same-sex marriage.
No, it's not about the use. It's about when a person is creating speech, it is what is the message that they are expressing. The Hurley framework asked this court to first look at, is there speech? And there clearly is. Words, graphics, text, videos, pictures, that's speech, and it's generally protected. The second is to ask, is the speaker's message affected? And when you're requiring a speaker to create a message to celebrate something that they believe to be false, you're compelling their speech and it's affecting their message.